Hello, good evening, everybody. Welcome, welcome, welcome. I'm just finishing getting set up here. Hopefully, I'll be able to finish getting set up here. It's been crazy. These are some crazy times. Goodness gracious. Hello, everybody. Oh my goodness. Oh my gosh, goodness. I'm not sure what else to say other than what? What is happening? What's happening out there? It's crazy. But welcome in. Happy Monday. I'm not a big Monday fan, but you know, what are you going to do? That may be the least of my concerns. So I'll keep going forward. Hello. Oh, I don't know. I don't know. Oh my goodness gracious, everyone. Oh my gosh. Are we making it? Are we making it through? Are we doing okay? Happy Monday to you as well. Hello, Meme NATO. And as per usual, I have to remember to watch some Sharknado soon. Trying exactly. Oh, I know. That's sometimes all we can do is just give it a try. And Nia, hello. We are still here. That's right. So that's good, right? Knock on wood. Tweet. That's good. I'm a little early. I had said I would be here at 7, but I thought, well, I'll just hop on a little bit early because everything's crazy. So I'm going to be a little crazy too and go on a little early. Simply Curium, hello. Welcome in. Welcome. So, 'tis the season. Absolutely. Yikes. So I thought, given the current state of what's going on in reality, I guess, I thought, it's been a while since we've been through the Constitution, and that's one of my favorite things to talk about. So I thought, showing the truth, I do try. Hello, Leah. So I thought, well, let's just go through the Constitution a little bit. Let's kind of clarify a few things. The Constitution is going to be in the media for a long time to come. We have a lot of moments where we're really needing it. Some people need a copy of this. So true, Sylvia. True. They really do. So this is one of my favorite copies of the Constitution. Now you can get whatever works for you. It's made in a ton of different languages. This is one of my constitutions here, and I've got multiple others, as I'm sure a lot of you have your pocket constitutions. But I do like to use the National Constitution Center PDF when I'm working through annotating and kind of going through and explaining the Constitution. That's one of my favorites. Oh, thanks, Sylvia. Hello, Duchess. Hello, old Stogie. Hello, welcome. Oh my gosh, that cracked me up. Welcome. Yes, well, kind of Big Mac. Yes, it's partial credit. So this is the copy that I use. Now, I would have to say to everyone, if you ever get a chance, if you're ever in Philadelphia, to swing by the National Constitution Center. It's amazing. The whole center is amazing. I've been there multiple times because number one, I'm a dork, and number two, it's just really cool. So, hello, Betharoni. H. Titus, welcome. Well, thank you so much. Late. Oh, I'm sorry. I'm not gonna say your name right. Oh my gosh, Leo Loney. Leo. Hello, Omar. Sorry about that. I'm talking to you. Freeman's Auctions. Oh, yeah, that'd be very interesting. Hello, Sarah. So they just have a ton of resources and at the center, and you can go in and kind of walk through and look at different exhibits. It's a museum, but it's also more than that. Now they have one particular presentation that they do, and it's like 360 degrees, right? So it goes around the room and with this very dramatic reading and the history, and it's just amazing. So we love it. Lonnie, okay, thanks. I appreciate that. Yikes, Lonnie. Sorry about that. Oh my goodness. Okay, spell pool. All right. Welcome. Thanks, villain. Thanks so much. Any more that were well, yes. And I'm glad you asked me that, A. Lopez, because that question is really on everybody's mind, I think, these days. And I thought that would be another good reason to go through it and kind of talk about it, break it down, see what's working. I am doing better. Now, I will give I will give my little piece here. What are you talking about? Hello, Kea. Welcome. Right. Oh dear. Oh no. Let me see here. Okay. I know we've got a lot of new bits and bobs. Of course, Linda, I'm glad to help. I'm glad to help here. My new system doesn't have my bits set up here. So yeah, Navy Vet, hello. Oh, they're gone. Thank you, Kea, so much. I appreciate it. All right, what was I going to say? What was it? I had something I was going to say. Oh, disclaimer. Little disclaimer, everyone. So today, I don't know, maybe it was around about 10 a.m. this morning. My, oh, thanks so much. My jaw locked on me. So if you've got TMJ, I mean, you know, it's no fun. I really don't ever have problems with it, really. I can't even think of the last time it's locked up, but it has slowly unlocked, but it's pretty sore. So if I start, lisping, just bear with me. Bear with me here. Really, yeah, it certainly can be. I'm very thankful. My personal experience is not that terrible. I'm so thankful. Really, that's interesting. Hello. Well, it's okay, Paco Taco. I'm feeling better now that I've been able to come on and hang out. Oh, yeah, the Constitution. I think we've got to talk about it. I think we really, this is one of those things that we just have to dive into it and swim around and see what's going on. Schwarmhammer, hello, welcome. Hello, he's out. Oh my gosh, I'm so glad, Crafty, you told me that. I've been like, oh my gosh, I hope everything's going okay. Oh, I've been worried. Oh, thank you so much for sharing. That really gives me a lot of relief. Bless him. Bless him. Well, right. Yeah. I mean, learning, I think, is one of the most important things. So this is my Constitution, everybody. This is the one I teach off of whenever I'm doing like a Con Law 101, this particular one, and several of you have seen my post where I was looking for the Declaration of Independence. I lost my favorite copy of it, but yes, I'm finding now I'm finding everything, thank goodness, so I'm back in it. Whose job is it to actually uphold the Constitution? Great question. And truly, I believe the intent, depending on who you talk to, but the intent is that the judiciary would be enough of a step out of the political conflicts that they would be the ones to come in and say, this is part, this is not part. And that was a really big piece for Thomas Jefferson. He was really, like, hey, this is it. We have our courts that are outside of all of the political frenzy. And so the courts were part of it, even though at the time when it passed, they didn't have judicial review. They didn't have jurisdiction to hear a lot of the cases. So for the first, 10 years, I think John Jay was the first SCOTUS Chief Justice. They just spent the time figuring out whether or not they had jurisdiction. So, and that really hasn't changed that much. That's what we really focus on quite a bit. I am feeling better. I may start lisping at any moment, so forgive me, but I'm okay. But when we look to the Constitution and we look to the drafters of the Constitution, I mean, there's a lot of things. There's a lot of ways that it can go, because we've got Thomas Jefferson coming in and saying, this is supposed to be something that can evolve, right, with the times. And Madison's like, let's not make the mistakes we made before with the Articles of Confederation. Let's do better. And then Hamilton coming in and saying, well, we're going to draft 7 articles and then that's it. We don't need any more. Because he looked at the articles as the rights, and he felt that they would be able to stand independently on their own. So he wasn't a big fan of the Bill of Rights. Of course, Madison and Jefferson were, along with many other people. But when we go back and we look at the Federalist Papers, which you probably have seen a lot being cited, and the Anti-Federalist Papers, which were primarily written by Patrick Henry, who was an amazing speaker, they're really diving back into it. The court is, when it comes to the Constitution right now. And we saw that with the Chevron doctrine most recently, of course, the immunity case as well. So they're jumping back to look at the intent, but we have to remember, like, that's the intent at that time, which was a while ago. So it'd be all right to also go forward. And we've got a lot of people that agree with that. I would remind everybody gently, I would remind everyone that we did have a liberal-leaning Supreme Court with Justice Warren back 60s and 70s. I think he left, actually, he was out the very end of the 60s. So we had some really amazing cases come through, right? We had Miranda versus Arizona, Mapp versus Ohio. We have this question on cruel and unusual punishment for the 8th Amendment. So there was like a moratorium put on it. The fact that if you can't afford an attorney, you get one appointed. It was huge. It was a revolution in the justice system. Now, right after that, it went very conservative. And remember, too, Chief Justice Warren was a swing vote. He was a swinger. He didn't always vote one way or the other. It just depended case by case by case. So after that, after the Warren court was over, I think the next one was Powell, I want to say. I'm not sure. I forget. But that was the end. That was the end. After that, after the Warren court, they have all been conservative courts. And we've had, I think, like 13 justices appointed by conservative presidents. So when you look at the history, what went down with Rehnquist, which I think was one of the most conservative courts ever, when you look and see, it's like, we haven't really had a lot of liberal stuff going on, because it's just not risen yet to that level, especially in the 80s when we had the crime and punishment movement after the attempted assassination of President Reagan. So just to kind of keep that in mind, a lot of people are like, oh no, the Supreme Court's so liberal. Like, well, no, actually not since the 60s. Burger, thank you so much. I appreciate that. Yeah, to progressiveness. Exactly. And it continues to be very slow. Hello, John. Good to see you too. I think one of the things, though, that is very different from the before times versus now is that people kind of paid attention more to the Supreme Court and the power of the court. And I think that was a result of what happened during the war, honestly. I think they recognized that they needed to know who was on the court, but those times are kind of over. So a lot of people just don't pay attention. It's not that big of a deal. Hello, Danny. And I think something is important for people to do that. So that's kind of like my little intro here that I like to share. And so we, again, with the Rehnquist court, and then with the Roberts court, and Roberts actually was a clerk for the Rehnquist. So there's a lot going on there. Right, right. LT. Yeah, right. I mean, don't get me started on that one. Not a big fan of the Rehnquist, but that's just how it's been. So when someone's like, "Oh no, we have this liberal court," like, no, we've not had a liberal court since, you know, the 60s. So, and that was a long time ago. It seems like it was only a couple decades ago, but that was like a really long time ago. So keep that in mind as we go through. Now, again, I do like to go through the Constitution, the articles first. We'll go into the 7 articles, and I want to break those down for everybody. We got a ton of clauses. You probably hear about all kinds of stuff like the citizenship clause or whatever. So I've pulled the clauses out so you can see exactly where the clauses are, the privileges, immunities clause, and so forth. So I'll take us through the 7 articles. We'll see if we've got time, because then we can kind of jump into a few of the Bill of Rights, but we'll have to see. I really want to emphasize how important it is, though, to remember, everybody, that the 7 articles are the Constitution. That is the Constitution. Everything that happens after that, with Madison bringing in the Bill of Rights and such, that's all additions years later. So here we go. Who's the longest serving justice? Yeah, Archie, I think you're right. I think Thomas is definitely there. Yeah, right. All right, so I'm not going to do a sticky note on this so that everyone can get a screenshot if you need it or whatever, because I think it'll be pretty clear what we're going through here. All right, let's dive in, everyone. Here's our preamble, right? We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So very famous, of course, and some people have tried to use this as justification in court, especially recently. Like, well, if you look here, we're guaranteed to have this like perfect union and blah, blah, blah. And no, you can't. The preamble's not like legal precedent that you can use to argue your case. It's beautiful, but if you're standing in front of the Supreme Court and you're like, well, according to the preamble, they're going to be like, what are you talking about? All right. I am feeling better, dude. Thanks for asking. All right, so let's dive in. Article 1, of course, setting out the legislature. Now, as I go through this, I would, and I have marked where the pieces of the original document no longer apply, right? Because of various different amendments and things. So if we get to a piece that is not really applicable anymore, I will let you know and then explain how the amendment changed it. So here we go, Section 1. Article 1 is the longest of all of the articles. Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And we know, of course, the Senate and House of Representatives, how those are chosen, became what was known as the Great Compromise, right? Section 2. Now, how this is cited whenever we do cite the Constitution is that we will put the section first, right? And then we'll add the clause. Each different paragraph here is a different clause, or, some of them aren't paragraphs, but each one of those referred to as a clause, and some people refer to the sections as paragraphs, but that's incorrect. A section is a section, and then the clauses are separated out here. So, hello, Katie. Section 2, the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. So again, 7 years a citizen, And they set that out for elected people except for the president. That's a little side note there. Clause number 3 was knocked out with the 13th and 14th Amendment. So this will be our first walk down the road. This was knocked out. There was no way to kind of scratch things off or white it out. So we had to add the amendments. So here we go. Representatives and direct taxes shall be apportioned among the several states, which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all other persons. So, of course, this piece is, of course, no longer applicable for anyone. 3/5 a person clause is how they would label this, along with our indigenous people, right? So there's taxes involved and such now. So this particular piece here has been made no longer usable. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years. That's why we do the census, right? In such a manner as they shall by law direct, the number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. So this was the original set of representatives. All right. Now, there were a couple of primary cases that came through here as well. Section 1 and Section 2, I would just remind you that the big cases here on legislative power are going to be Baker versus Carr and the Chevron case, and the doctrine came through here as well. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment. This is important too, because I would note, everyone, when we get to Article 2, all officers are supposed to be appointed by the president. So whenever it's saying specifically they can choose their own officers, it's because they're distinguishing it from those that can be chosen by the president. All right, next, Section 3, and we've got, again, a couple pieces here. So clause number 1, the Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. This was changed in the 17th Amendment. So the state legislatures were the ones choosing the senators for Congress, and then that was changed to the popular vote through the 17th Amendment. Immediately after, they shall be assembled in consequence of the first election. They shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the 2nd class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. So this is where we get every election, every 2 years, we're re-electing or electing our representatives, right? And what they've done is divided the Senate into 3 different parts. So 1/3 of the Senate will be up for election, but then the next time it'll be the next third and the next third, so that it there's not as many up for election as the houses. The whole house is available at this point. And this piece here, and if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. All right, so that just, again, has to do with what happens if someone can't do the work. All right, so that's clause number 3. Now we're still in Article 1. Again, reminding everybody that this is the longest article. Oh, I know, VC. Oh, I know. I don't know what's going to happen with this crazy place here. All right, clause 3. No person shall be a senator who shall not have attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he shall be chosen. Clause 4, the Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. So for anyone who thought the Vice President's just like, why aren't they voting and doing stuff? Well, they can't under the Constitution. Clause number 5, the Senate shall choose their other officers, also a president pro tempore in the absence of the Vice President, or when he shall exercise the office of the President of the United States. Clause 6, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall, on oath or affirmation, when the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So that's our super majority that we needed in order for that to go through. Now, historically, we have not had a conviction in the Senate for impeachment of a president, but we have had convictions for impeachment for federal judges. So it has happened before. Very rare, but it can actually happen. A judgment in cases of impeachment shall not extend further than to removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Clause 7 here was something that was a huge fight when we were working on the espionage case out of Florida and then the DC case. This question came up whether or not there would be some kind of disqualification for Mr. Orange, and also whether or not impeachment was appropriate when there were criminal means available. If you'll remember, Mr. Turtle in the Senate was like, we should leave this up to the criminal courts, blah, 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 blah. Meanwhile, the criminal courts are like, man, we're going to go. This was very controversial. So clause 7 here of section 3. If you came up to me on the street, possibly, I may need a couple of hints, but just with this first article, because it's so dense. You know who I'm talking about, Willie B. You know. Oh, my goodness. All right, here we go. So that's clause 7. Section 4. This is our election piece, right? So when they're saying, what's going to happen to our elections? This is where we're getting the rules for the election, right here. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. So this is really important. This is where the states have the power to set these elections out, and Congress, which you may or may not know, can kind of clean things up a little bit, which is what they did with this whole question of whether or not the vice president could, send the votes back to the states. I got to be careful with my language here, everybody. But there was that question, right, regarding the VP. And so what Congress did was passed a law amending the verbiage to make sure that would never happen again. So they do have that area. I know. I know, it's a bummer. I don't know what's going to happen, everybody, but all right. Next, the Congress shall assemble at least once every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. So that's been changed by the 20th Amendment, the timing of that. The reason this is here, just as a quick side note, is because in the Articles of Confederation, the Congress was very weak, which wasn't great because there wasn't an executive branch or judiciary. So you had a weak Congress, no judiciary, no executive branch. So, there were troubles, there were problems. The biggest problem was attendance. So what happened during the Articles of Confederation is that nobody would show up. Like they would be supposed to be going to a Congress and they're like, man, we don't want to. And so, or they would just ask their buddies. Like if they were at a pub, there was one story. If you're at a pub and your buddy's like, what's up? You could be like, hey, do you mind showing up for Congress for me? I'd appreciate it. So that was a problem. That's why one of the things they wanted to have in here was to say, you can't just go 2 or 3 years without, holding Congress, without having that. There needs to be some rules here. So that was set. And then, of course, the dates were changed. So we didn't have such a lame duck situation going on. All right, Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. So this is kind of hinting at what had happened in Texas, right, when they were not able to get enough people. Next, clause 2, each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. And they have done that before, and actually in recent years as well. Each house shall keep a journal of his proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. So there you have it. Neither house nor the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the 2 houses shall be sitting. Again, going back to those Articles of Confederation when they just didn't show up. Nobody showed up, or else they said, well, we're going to meet, over here this time. So just trying to solidify what those parameters are here. Section 6. Clause 1, the senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States, which was another issue with the Articles of Confederation. Nobody was getting paid. Nobody was getting paid because they didn't have any money, because the states could voluntarily pay some taxes, but they didn't have to. And so they didn't. So they didn't have any money. So they weren't getting paid either. They're like, man, we're not even going to show up. We're not getting paid. We don't care. Or like get some kind of like person to just, can you show up for me? Great. They shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. So this piece, everybody, this is that speech and debate clause. This is a part 2 that the justices were talking a lot about in the immunity case. They were saying, why is it that our congressional people have this immunity for not being arrested, in Congress or being held accountable for something that they're saying in the course of their official duties. And yet we don't have anything set for the president. So I'm not saying I agree with that. I'm just saying that was part of the rationale here. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. So, yes, welcome, Nani. Good to see you. So this is another question that I have. We've got, oh my gosh, the angry dude. What's his name? He's like the Deputy Attorney General, but he's also, I think, in charge of the Library of Congress. I can't remember his name. But, I'm assuming that complies with the requirements. Blanche, thank you, VC. Yes. Yes, that's right. All right, here we go, section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Clause 2, every bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approves, he shall sign it, but if not, he shall return it with his objections to that House in which it shall have originated. Who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered. And if approved by 2/3 of that House, it shall become law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the president within 10 days, Sundays excepted, yikes, after it shall have been presented to him, the same shall be law. So if he doesn't get back to it in 10 days, it becomes law. In like manner, if he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be a law. So if Congress is like, we're getting out of here, then it wouldn't become the law then. Clause 3, every order, resolution, or vote to which the concurrence of the Senate and the House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of bill. So again, we're talking about this supermajority. Now, Section 8, I know this is like we're in the weeds, everybody, but the weeds is where our courts are right now, and also where people are trying to twist things up, right? So the more we can go in and look and understand what it means, I think the easier it is to understand what people are doing right now. All right, I'm not trying to bore you. All right, Section 8, here we go. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. So that's the general welfare clause. But all duties, imposts, and excises shall be uniform throughout the United States. We got sidetracked with Angry Bird Blanche. Oh, that's so funny. Oh my gosh. Oh man. I keep thinking about how much cleanup it's going to take when all this is over. All right. So these are each their own clause. So if you're like Article 1, Section 8, Clause 7, it's because they're going through each of these different pieces here. the last clause. Okay, so section 7 here, you're talking about, oh, you're so sweet. Thank you. Are you talking, Sarah, are you talking about the pieces of the 8th? The 3rd, number 3? Or one that we've already done before? 7-3. 7-3. Okay. So here, down here, this piece, 7-3, discussing the, right. Well, that's interesting though, isn't it? Because nowhere in here does it say, okay, got it, that there are provisions allowed for the president to set that, right? And we'll get into that here in the next piece. Let's go back for a minute. Section 7, clause 3. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States. All right, so when we've got the concurrence of the Senate and the House of Representatives for orders, resolutions, or different votes, they're going to show that. They present it then to the president. And before the same shall take effect, so before whatever it was they were working on and voted on comes into play, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives, according to the rules and limitations prescribed in the case of a bill. So this again is just explaining, this is kind of like our bill on Capitol Hill moment, right? So if they're coming in and they've got an order, resolution, or a vote, both sides have come in and voted on it or done what they've needed to do, they're going to present it to the president, and then the president will be like, all right, looks good, or no, we don't like it, and then they go back and they mess around with it until the president is agreeing. Right. Congress and the Senate can cram it through without, right. So, and again, up here, we've got this distinction because they set out what the process is for a bill up here, but they're talking about basically anything else. So, for example, the impeachment for Mr. Orange was actually called a resolution. So that wasn't a bill that needed to be passed. That was a resolution, to give you some idea. So that's something, again, this is the process if it's not a bill. Does that make sense? There's a bunch of trolls. That's funny. Real life works. They also can't, right. That's a mess. That's the Cook case, right? Yeah, that's a mess. Right. So up here we've got bills. Down here we've got orders, resolutions, or votes, whatever it is, however they format those, and they've got to be approved. Oh, thank you so much. Yes. Oh, had to have some fun nails for tonight. All right, back in it to win it, everybody. Section 8. The first clause up here has to do with provide for the common defense and general welfare of the United States. That is Congress's job. All right. We have pieces over in Article 2 that we'll go over where we're trying to uphold the laws. That's fine. But the common defense and general welfare of the United States, that's a Congress's job. All right. But all duties, imposts, and excises shall be uniform throughout the United States. So we need everything to be the same. All right, so to borrow money on the credit of the United States, so the president can't borrow any money at all, all right? That's not allowable. To regulate commerce with foreign nations and among the several states and with the Indian tribes. So this is the Commerce Clause. This is where our problem with our tariffs, well, we don't have a problem, but the executive's having a problem here. Because regulating commerce, that's a big piece of what tariffs do. Now, I'm not going to get into a tariffs discussion because I'm not going to do that. But what I will say is that the Commerce Clause leaves the regulation of commerce up to Congress, not to the president. So in order for the president to go in and dink around with tariffs, it has to be some kind of law passed by Congress that allows that to happen, because they can regulate themselves out of the picture, basically. So what happened with our tariffs is that in emergency situations where there's like insurrection, or countries, whatever is coming to get us, then that's where this regulation of tariffs can come in through the executive branch. All right. And that's the IEEPA piece that we've been talking about a little bit. But Congress is supposed to do that through the Commerce Clause. The other thing, too, is this emergency law that the executive branch is using. All of those emergencies can be halted or stopped by Congress. All right. So if the president's like, oh, we're in an emergency under IEEPA, then Congress can come back in and be like, nope, it's over. It's done. And they could set that out, and then that would pull all the power away from the executive to be messing around with the tariffs. Right, we're all paying for the drama. Yeah, true story. All right, so Commerce Clause, very important, and that is our third clause here. All right, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. I'm not sure why naturalization and bankruptcies are in the same clause, but whatever. So again, it's up to Congress to set out naturalization and Congress's power there, as well as bankruptcies. The president does not set out rules for naturalization. All right, that's not his job. That's Congress. All right, next here. Well, Kaya, I think I would agree, and Congress is definitely moving pretty slow. But if you're looking at it from my perspective, I'm seeing the amicus curiae briefs being filed by legislators, like by senators and representatives, saying, hey, this is what Congress meant, and it didn't mean this. And a lawsuit that's already been filed as well. So we've got half of Congress suing the president. So they're there. It's just what they're doing is very slow moving, for sure. And quite frankly, they could speed it up. That'd be all right. Next, to coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures, right? So somebody made that bad choice instead of being on the metric process here. Also, this whole idea of coining money, those were some of the hottest cases in front of the Supreme Court when the country first got together. So there were some issues regarding this, because some people were like, we don't want the coin money. We want to use the money we've been using. And they're like, well, that's British, and so you can't use it anymore. That was very controversial. Next, to provide for the punishment of counterfeiting the securities and current coin of the United States. All right, so that's a crime set out. To establish post offices and post roads. Again, very important. And even though these are put together, these are two separate clauses here. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So patent, trademark law, that's set out here by Congress. All of that, and the science is really, important. Even then, when they're like, drinking mercury or whatever, or putting like, mice in their wigs, whatever. Even then, though, they're like, ooh, science. Maybe we should look at that. Oh, you work in patents. Oh my gosh, somebody has to. You're doing amazing work. Thank you. All right, next, to constitute tribunals inferior to the United States. So inferior tribunals, that's the federal courts, like rude. To define and punish piracies and felonies committed on the high seas, and offenses against the law of nations, right? So like, the international treaties and such. We had some piracy issues going on quite a bit when the Declaration of Independence went over to King George. Jefferson had been like, dude, stop taking our people and forcing them to work for you on the high seas. So that was a bit there. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. So of course, this declaration of war peace was very important, and the intent was so that your elected people were deciding whether or not there was a war. But then the president started to get kind of like, smarty pants about it, and started, flying people over to Vietnam or Korea, and they said Korea was a police action. So that's how they got around that. So it's been the presidents that have been dancing around this one, but Congress is supposed to be the one to declare war, which is also what the Alien Enemies Act requires as well. Yeah, right. Moving on. To raise and support armies, but no apportionment of money to that use shall be for longer than a term of 2 years. So again, they put this limitation on that. To provide and maintain a navy, to make the rules for government and regulation of the land and naval forces. I think it's really important to note what role Congress has here, because we have someone who's like, I'm the commander-in-chief of blah, blah, bloody, blah, blah. And it's like, great, but Congress is still involved here. You're not just like taking a group of peeps out and doing whatever you want to do. No, look at this. Look at all this stuff Congress is supposed to do when it comes to our military. All right, so, check, check please. So to provide for the calling forth of the militia, to execute the laws of the Union, suppress insurrection, and repel invasions. So, right. So the National Guard, like, that's up to Congress. Again, the only reason why the executive branch could get involved is by using an emergency declaration statute that allows for it. And like in such situations where, basically we're under attack, the executive branch can start pulling in, the militia people. That's the biggest problem with these lawsuits for the administration, is that it's like, well, there's not one. And saying, well, the crime in DC is out of control. Like, well, that's not enough to call in the militia. And it's right here in the Constitution. I know we've got like 6 emergencies declared right now. And again, each one of those unlocks a different like superpower that the president's attempting to use. So we need the courts to come in and say, all right, no, but then that's taking forever. All right. So just remember that clause 15, everybody, the militia is under Congress here. All right. To provide for organizing, arming, and disciplining the militia, and for government, such part of them as may be employed in the service of the United States. Again, more militia powers to Congress, reserving to the states respectively, and then power to the states, the appointment of the officers and authority of training the militia according to the discipline prescribed by Congress. So this one, they're splitting it. So they're saying Congress has half of the authority, and then the states have half of the authority. There's not a president included here. No president here. Nope. But when it comes to our militia, they were pretty clear about who is going to be there. All right. He's the emergency. Oh my goodness. Allegedly. Oh my goodness gracious. All right, everyone. There's only a total of 10 sections, so we are coming down to the finish line here. The last couple pieces, again, this is basically, I look at Section 8 like it is the job description for Congress. And this is also, each and every single one of these is what gets challenged in court when they are saying the president is over extending his power. He's in a world that's beyond his reach. They're using each of these pieces. So for the tariffs, it's the Commerce Clause. For the militia and the National Guard, it's clauses 15 and 16. So again, maintaining the Navy, there's just so many things in here that Congress is supposed to doing. I mean, there's a ton of choices, but it takes time because you got to go through the court. So, right. Can't fire cook. Oh, well, let's hold on to that. Let's hope that's true. All right. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines? Hold on, everybody. Magazines? All right, that must be some kind of weaponry. Magazines, arsenals, dockyards, and other needful buildings. Sorry, my bad. And to make all laws which shall be necessary and proper for the carrying into execution for foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. So again, there's the pieces of what Congress is supposed to do and what the executive branch is not allowed to do are set out here. So we have the necessary and proper clause, which is a huge blanket clause and used quite a bit by, all right, who's that wrestler guy, everybody? That wrestler guy that seems angry all the time. He's like, rah, 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 I want to know what's going on in all the criminal cases, blah, 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 blah. So he's using this argument, like, because I'm in Congress, I need information on what's necessary and proper. So he would use this as a reason to try to go after getting indictments and stuff from Georgia. Oh my gosh, what's his name? I'm terrible with names. What's his name? So he's like this Southern wrestling fella, I guess, and he was like going off after D.A. Willis, and he was going after the New York case. He's like, give us all the information. We want to have everything because I need to know what's necessary and proper. I don't think he's from Montana. He's got like this real, he reminds me of Hulk Hogan, not as tan. I'm trying to remember now. Like, he's just kind of a real schmarmy guy. I think he was involved in some kind of, hello, Betharoo. He was involved in some kind of like questionable sports issue. That was that Jim. That sounds right. Yeah, that sounds right. Jim something. Jim Wrestler. Vince Mahon. Ooh, Steve. No, Jim Jordan. OVC. Yes. Thank you, everybody. That was a group effort. Okay, we're winning. Yeah. Jim Jordan. Right. The wrestling fella. Right. Y'all remember that? He was writing letters to D.A. Willis, and then she was like, I'm sorry, what'd you say? I think we'd write another one, and she's like, no, we're not going to do that. Oh, the WWE. No, that's the Department of Education. Yeah, my bad. Thanks, everybody, for helping me. That was a long walk, but it was worth it. I appreciate you. So the point was of my story that makes no sense with the angry wrestler fella is that these committees asking for this information, rather than being like, well, of course it's relevant, they will use this necessary and proper clause as a catch-all for excusing or for allowing their behavior that's questionable. World Wrestling Entertainment? All right. Yeah, all right. My goodness. That one was wrestling. I forget. I only think of like the... when I think of wrestling, I think of like the Olympics, but I guess it's no longer in the Olympics. All right. Side note, coming back. Let's get back on the road again. Here we go. Section 9. All right. Here's clause 1. We had a civil war, so that kind of put these out. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. All right, so this is awful. This is part of our history. and this is obviously no longer applicable. It does not apply. But I will take a moment to note, when we have things like this in our founding documents and in our founding history, and people are like, well, we don't want to talk about it because it makes people feel bad. It's like, well, are you going to white it out of the Constitution? Because it's right there. It's right there. So that's very frustrating to me when I hear that. It's like, well, we're not supposed to teach kids about this stuff. I'm like, well, how are they going to understand what happened here in Section 9, Clause 1, right? We haven't gotten rid of that. So that's my soapbox for the moment. Very frustrating. They do try. They do try. It's just, I mean, it's right there. It's right there. I've had several people be like, well, that was a long, long time ago. I'm like, not that long ago. We're still using this document every single day, and this is still in there. So, yeah. Yeah, I know. Well, I mean, all right. Okay, putting away the soapbox. Here we go. Clause 2, the privilege of the writ of habeas corpus shall not be suspended unless when in the cases of rebellion or invasion, the public safety may require it. So, we've had a lot of questions about this habeas corpus bits and bobs. I would say probably the most important one that set the most precedent, or attempted to, was, of course, what is it? Ex parte Merriman, I think I'm not sure if it was ex parte. Ex rel Merriman. And that was where the Supreme Court said, bring me this dude at the fort. And Lincoln was like, I'm not going to do that because I don't like you. So Lincoln basically suspended habeas corpus. And Congress was like, well, we weren't in town when this happened. I feel like Congress never really shows up. So I'm wondering if we're really in an unusual place right now because of Congress, or if this is just more of the same. Because they seem to be out of town a lot. All right. So habeas corpus here. I'm sorry, everybody. Sometimes I just crack myself up. I gotta drink some tea. Oh my gosh. Right, Grant. Oh, I know. Grant. Man, that's like, you got to know when to leave. Like, walk away, Grant, walk away. All right, here we go. So next we have no bill of attainder or ex post facto law shall be passed. So what they're trying to say here is you can't just make something that you don't like illegal in order to go after particular people or a particular crime. So in ex post facto laws as well. So like, well, we passed this and you did it 10 years ago, so we're going to put you in prison. You can't do that. Next, no capitulation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Now, this was basically all they had for income tax until the 16th Amendment was passed. So again, and as I was saying, they made it voluntary during the Articles of Confederation if the states wanted to pay. So they'd be like, hey, New York, can you, send us some money over here in Congress? And New York's like, F you, I got stuff to do. Because that's how New York is. They got a lot of stuff to do. So they didn't have any money. So they tried to phrase it in a way that would allow some money coming into that federal government here. Does the Constitution explain what an emergency is constitutionally? No, it does not. It does not. So what we have to look at is the case law. And that's what our courts are doing quite a bit of, is they're going all the way back. And if our case law is unclear, which it kind of is, then they go all the way back in England. They go to England. They're like, well, this is what happened in England. That's why I bring up the Magna Carta so much, because I'm like, we use this every day, Magna Carta. But it would be nice if it was. And so we kind of have to fight out what the definition is of an emergency, and then the U.S. Supreme Court makes the final decision. So that's frustrating, right? We can do that. What, go back to the Magna Carta? Yes. You'd think we'd be considering how, right. Yeah, I mean, we literally fight it out, and they'll bring in the Federalist Papers, and say, well, this is what we thought was going on. And then they'll even bring in like how the king dealt with stuff at the time. That's why it seems like each one of these cases that's coming out in this administration is like a little mini history lesson, because they've got to go so far back in order to figure out the definitions. All right. So income tax would be under the fourth clause, Section 9 of Article 1, and it's not great. So we have the 16th Amendment passed here. All right. So no tax or duty shall be laid on articles exported from any state. Okay. All right. No preference shall be given by any regulation of commerce. Oh, I got the puzzle, everybody. Okay. Oh, pray for me or wish the Big Bang's help. All right. Phew, we made it. That was scary. Oh my gosh, the puzzle thing. Can they change that when they're changing everything else here too? That'd be great. All right. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. Again, this was a huge issue. And one of the, a lot of people forget about him because they're like, oh, his signature was so big. But one of the most important, in my humble opinion, founding fathers, of course, is John Hancock. And he was a smuggler. Well, I mean, he was a businessman. But there was a lot of business to be done with his ships, floating all over the place. So when it came to any kinds of duties, any kinds of things for trading off of different states, he was all over that business. Next, no money shall be drawn from the treasury, but in consequence of appropriations made by law. Hello, this is the withholding of all of the frozen federal funds. That's right here. That's right here. And a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. So, all right, it's got to be subject to appropriation, or else we have an impoundment issue, which is not legal, which takes forever to get through the court. Right. All right. The title of nobility. No title of nobility shall be granted by the United States. As a quick side note, it's actually been proposed as an amendment to the Constitution, and of course it's never passed. But it seems like every few years, this issue of Congress being able to title someone will pop up again. So if you look at amendments that have not passed and titles of nobility, you'll be able to see that. See where we're doing it. If it's in the Constitution. Well, because we're kind of like, here's our structure here, but the finite details have to go through the legal system in order to figure out the definitions and the jurisdiction. So it's our foundation, but we can't live on a foundation. What kind of titles? Well, titles of nobility. So I would say, I don't know, what do they have there? Like knights, or all I can think of is that guy Sandwich. What's his name? It's like, you know what I'm saying? Like the all the British ones. Oh my gosh. Sorry, everybody. I can't. All I can think of is the sandwich guy. And then I'm like, I want a peanut butter and jelly sandwich right now. And I know that's off. Duke Lord Earl, thank you. Oh my gosh. Oh, what would I do without you? Barons, right? Lords. Oh my gosh. Thank you so much. Hello, Spooky. Or Marquez. Yeah, that'd be really cool. Who's been watching Bridgerton here? Right. Or the Viscount. I always thought it was Viscount, but I was wrong. The Viscount. All right. So right. I don't know why, but I've been obsessed with sandwiches lately, everybody. Franklin Pierce have a chin. Right. They were. Those were the big questions at the time. And I think Jefferson and Adams, like truly the part when they're, I believe, you can fact check me on this, but where they really fell out not being friends was I think it was Thomas that wrote something about Adams and his mother. So there was some kind of mom inappropriate situation occurring. And so Thomas Jefferson like put it in a paper, and John Adams was like, well, that's it. We're done. We're done. So that was what really ruined their relationship. Right, right. Living Nielsen. Oh, thanks. Oh, all right. Enough of that. It reminds me of another magazine person who got really, really, somebody got really mad at him for doing a piece on another person and his mother. I know, the mom insults, right? Right. All right, moving on. Sorry, everybody, moving on. I'm really squirrely tonight. No title of nobility shall be granted by the United States. No person holding any office of profit or trust under them shall, without the consent of Congress, except of any present, right? I don't know. Is it plain a present, everyone? I'm not sure. The emolument, office, or title of any kind, whatever, from any king, prince, or foreign state. So Burger King's out, Dairy Queen's out, like Purple Rain out, all of those things. It's not allowed. Emoluments. Oh, thank you. I struggle with that one. You've been around long enough. You know I struggle with that one. All right, section 10, last one. Here we go. Speed round here. Speed round. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts. This is what we call the contracts clause. So if there's some kind of issue going on with a contract that's been put together. This is the Chisholm case here. Chisholm. This is the Chisholm v. Georgia case. Or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imports laid by any state or imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. Again, Congress is in charge here. King of rock and roll, that's right, gone. Forget it. No Elvis Presley presence here. All right. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. So my question then, everyone, if we're just doing whatever we want to do now and then just clean it up later, this particular piece right here, it's saying, without the consent of Congress, lay any duty, keep troops or ships of war, enter into any agreement. So, how upset is California going to be until they get to a point where they're like, we need to deal with the invasion? I mean, when are they going to say we're being invaded by, the feds? And if there is an invasion, then, they're going to have to put it through the court system? Imminent dangers involved? I mean, that's one of my questions right there. We're pressure charged. Well, right, and rightfully so. Right. National Guard's a little different. True. Especially in D.C. Secrets, really? Al Capone. Oh, really? Al Capone, great mystery. So yeah, that's my piece that I would leave there. At some point, we're going to get into some troubles here. All right. So you can also read the Heller case, and that explains much more clearly militia situations, because there's no way to talk about the National Guard and militia without including the Second Amendment. They just, they go together. All right, here's Article 2, everybody. So just finished up Article 1. That's the longest one. So here we go. We're going to make up some time in the air. Here's Article 2, Section 1. The executive power shall be vested in a president of the United States of America. He shall hold his office during the term of 4 years, and together with a vice president, chosen for the same term, be elected as follows. Each state shall appoint in a manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress, but no senator or representative or person holding any office of trust or profit under the United States shall be appointed as an elector. This came out, and we've been dealing with this for a very long time. Exactly how our electoral college works, how our electors work, came out repeatedly because of the fake elector scheme that was attempted. Now, multiple states involved in that have, brought people in and indicted them. There's a lawsuit in Wisconsin, a civil lawsuit, and that was settled. But the states that were involved in that, they were really upset. But this is how you go about picking your electors, all right? Which is weird because the way the Electoral College is set up is weird, but they did change it at least in the 12th Amendment. So I'm not going to take us through all of this because this is all changed now. But California's saying peace out. Yeah, I'm going to have to go there before they do that. like, hey, you got room for one more? All right, here we go. So this is the Electoral College bit, Clause 3. This was changed by the 12th Amendment and after the Alexander Hamilton situation as well. Next, the Congress may determine the time of choosing the electors and a day on which they shall give their votes, which day shall be the same throughout the United States, right? No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 and been 14 years resident within the United States. So again, very minimal requirements here for running. This is where our natural born citizen clause is. So in clause 5 there of section 1. Next, in case of removal of the president from office or of his unalive resignation or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, unalive, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or president shall be elected. So this has been replaced by the 25th Amendment, everyone. So this is like the order of what happens if the president's like going to a farm in upstate New York. You know what I'm saying here, right? So they changed this. And they changed it, of course, after JFK. That was really the catalyst for it. Because we had like, I think 8 presidents who had unalived during their presidency, and it was just all jacked up. Nobody knew what was going on. Even after JFK, they're like, what, are we swearing him in on a plane? I mean, what's going on here? So after that, Congress was like, boom, we need to set out what's going to happen if they go down. Like, we don't want to believe that people are going to, unalive, but they might. Let's just be real. And that's why we've got the 25th Amendment. Electoral College, right. So the thing too, Lily, about the Electoral College, and you might really enjoy this actually. If you go online, you can see, and I don't remember what you'd want to type in exactly, but I'm sure you'd get it sorted. But there's an amendment they've been working on for years and years and years. And it seems like it just evolves and evolves and evolves. And there is an amendment that they're trying to put forward that would actually do away with the Electoral College. So we wouldn't be dealing with that anymore. It's just they have not been able to get enough votes to get it going through. So at some point, who knows? Who knows? All right, the president shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected. And he shall not receive within that period any other emolument, I don't know, did I say it right that time? From the United States or any of them. So there, of course, is our emolument clause. Before he enter on the execution of his office, he shall take the following oath or affirmation. Also, this is another piece that was highly litigated in the Anderson case in Colorado for the disqualification of Mr. Orange off of their presidential ballot. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Now, there's been some talk saying, well, I'm trying to uphold my oath. And then other talk saying, well, my oath is different than everybody else's and I can do what I want with it. So, we don't really have a definitive answer on that yet. Thanks, Supreme Court, for that. Air Force One, really? Oh, my goodness. Oh, sad. All right, here we go. Section 2, and then we're going to get into the very exciting Article 3. Section 2, the president shall be the commander-in-chief of the Army and Navy of the United States and of the militia of the several states. So commander-in-chief, keep that in mind, because you can be a commander-in-chief, but Congress is the one that calls them up. So, again, we've got this fight between the legislative and executive branch. Let's just remember where that was at. I want to just make sure. Let me make sure here. Where is it? Oh, here we go. To provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasions. So to provide for calling forth is Congress's role. And then here, commander-in-chief and of the militia of the several states, when called into the actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. So this we've moved into the president gets to get updated on some stuff, and he shall have the power to grant reprieves and pardons. Right here, this is the one official presidential act that everyone can agree upon that immunity case would cover. So when he's handing out pardons, even if it's criminal, under the Supreme Court, he could still potentially be immune to that. Yikes. Except in cases of impeachment. So we can't do that. Clause 2, he shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States. So this is where that officers piece gets questioned. Who exactly is an officer in the United States? Who exactly in the federal branch? The executive branch of federal employees are officers, right? And if he can appoint them, can he also remove them? So that's, one of the big questions on the floor. This is what we call the appointments clause here. So, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So if Congress doesn't like what's going on here with how people are getting hired and fired, they could change it. They have that power. They have that authority. First, they'll make you miserable. Well, you're not wrong. The president shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions, which shall expire at the end of their next session. So there's a temporary break in there. Oh, thanks, Rick. Kennedy's name into existence now. Oh my goodness. I don't know how the Kennedy name is going to make it to the other side of this stuff. All right, Section 3, he shall from time to time give to the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in the case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed. So that's our take care clause. And what exactly that means, well, we're still figuring it out. It's a lot. It's a lot because he's saying everything that he's doing, including the emergencies being declared and the federal funding being withheld, are all him trying to take care. Right. And in particular, I think this is really an excellent piece to go to for the Harvard case. I spelled Harvard wrong. But in the Harvard case, he was saying they were discriminating against a particular group of people. And so therefore, he could freeze federal funding because they were discriminating against certain people. Here's Section 4. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So this is the impeachment clause there under Article 2. All right, here we go. See, they're getting shorter and shorter, everyone. The rest of these just go whoosh really quick here. So let's dive into Article 3. This is our court system, right? Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office. So there's that. And Thomas isn't very happy about that compensation. Section 2, the judicial power shall extend to all cases in law and equity. This is a big moment too, everyone, where we're having these huge lawsuits coming in, and they're having this debate between law and equity. And depending on how these cases are falling, it's going to change what the courts are doing. So arising under this Constitution, the laws of the United States and treaties made or which shall be made under the authority to all cases affecting ambassadors or public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, and that's kind of a gray area after the 11th Amendment, between a state and citizens of another state. So that's also the Chisholm case. So that was the Georgia case. Between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between the state or the citizens thereof and foreign states, citizens or subjects. So here they're saying, where's your jurisdiction? And then they came back with the 11th Amendment and said you can't sue a state unless they let you. So you have to get permission to sue a state. All right, next, in all cases affecting ambassadors or other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is really important, all right? The U.S. Supreme Court only has 2 levels of jurisdiction. That's it. And this is what they have set out in the Constitution. First, they have original jurisdiction, which means they're the first court. They're the trial court in this situation. They know what's going on. So original jurisdiction is like these are cases only for the Supreme Court. And they set it out here. So ambassadors, public ministers, consuls, where a state shall be a party, the Supreme Court shall have original jurisdiction. That means everything else is appellate jurisdiction. All right, so you have original jurisdiction, you're looking at exhibits and facts. If you have appellate jurisdiction, you're looking at paperwork. All right, so that's a big difference between the two. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to the law and fact, with such exceptions and under such regulations as the Congress shall make. And so that's what we call the exceptions clause. Again, specifically setting out the jurisdiction of the United States Supreme Court. All right. Oh, I know. Those were the good days, Patricia. Those are the good days. All right, next, the trial of all crimes. So this is a federal criminal piece, except in cases of impeachment, shall be by jury. All right, so that's important because without that, you wouldn't be entitled to a jury here. All right, and such trial shall be held in the state where the said crime shall have been committed. So that's the jurisdiction they gave over to the states. But when not committed within any state, the trial shall be at such place and places as the Congress may by law have directed. All right, so you're entitled to a jury trial, but you are not entitled to a grand jury indictment unless it's a federal case or your state constitution has it. All right. So jury trial here, just make sure I'm following along. Okay, section 3, here's the last piece. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. Keep in mind that probably the biggest time for the treason to be used was right after the Civil War. And so basically, you know, there's parts of our Constitution that people just don't have the stomach for and don't go forward on. No person shall be convicted of treason unless the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no bill of attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. All right, so that's section 3 of Article 3. Yeah, I'm just a bit past. You're right. But this is it. I'm gonna zip through these next ones. I can't leave everybody hanging on Article 4. That's not right. All right, here we go, everyone. Get your bananas in your water. We're gonna be just sprinting through this one. Yeah, get my tea. Here we go. All right, Article 4, Section 1. Full faith and credit clause here shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the efforts and the effects thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So this is our immunities clause, privileges and immunities clause. Keep that in mind because we have also got that in the 14th Amendment. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. So this is when we move criminals around from one place to another depending on where the crime is, right? And then this piece, no person held in service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service of labor, but shall be delivered up on claim of the party to whom the service or labor may be due. So that's called, thanks, extradition. I appreciate that. This is the fugitive slave piece in here, which is awful. And one of the most memorable times in our history when we've had jury nullification. Because the juries were like, this is crap, we're not using this. All right, next, section 3. New states may be admitted by Congress into the Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of the states without the consent of the legislatures of the states concerned as well as of Congress. This was before the Louisiana Purchase, by the way. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state. Section 4. This is a big one too here. The United States shall guarantee, this is our guarantee clause, to every state in the Union a republican form of government. Now, republican is a type of government, not a party, and shall protect each of them against invasion and on application of the legislature or of the executive where the legislature cannot be convened against domestic violence. All right. Next, we've got Article 5, and this one's really important too here. We don't have any clauses in there. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by convention in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to year 1808 shall in any manner affect the first and fourth clauses of the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. All right, long story short, we have 2 ways to add an amendment. Here we go. 2 ways. Either Congress can go forward, or we can call a constitutional convention. All of our amendments have all gone through Congress. We have never held a constitutional convention. Right. All right, here we go. Look, see, we're almost done. All right, Article 6, Clause 1, all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States. Right, so we got some debts. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. I certainly am. We're racing to the ending here, everybody. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So this is where we have our oath or affirmation clause here. All right, and then Article 7 is our last article. So just the last little piece here. Instead of, I know, VC wasn't very orderly. I think Madison may have been hitting the sauce too hard. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and of independence of the United States of America, the 12th, in witness whereof we have hereunto subscribed our names. And then the names of all of the peoples is included here. All right, so we made it. We made it through the end. And you might say, we didn't get to the amendments. That's okay, because the goal was to make it through the Constitution, and the Constitution is the 7 articles. Yay, we did it. We did it. I know there's something new each time, John. I know something a little bit different each time that you can understand and try to figure out, like, why is this like this? But as you can see too, though, one of my big things right now is that people are saying, well, the Constitution's gone or it's, been thrown out the window. I don't know. But, there's a lot to the Constitution. There might be a few pieces that, need to really be ironed out, but I do not see the fall of this Constitution as of right now at all. So that's something to kind of just remember is the structure here, the work that went into it, and the fact that the judiciary is what takes us through the document itself. Right. Everything came about. Well, yeah, pretty much. And a lot of people weren't particularly happy about it, but and I've pulled the Articles of Confederation out. I think Brian was also looking at those. Great minds think alike with Brian. Hopefully everyone's subscribing to him. But when we were looking at that, you can see where a lot of the holes were put. Yes, claim your points. HB 5300, I have not looked at that one. So I can take a peek at that. But with that, my friends, I'm over my time limit. So I will go ahead and sign off for now. Hoping to be back very, very soon. So take care of yourselves, everyone. And I will see you. And I will see you back again very soon. And his handle is BRYNODC. So there you go. Take care, everyone.